strong, clear advocacy voice as we've had in the past.
Mr Chair.
I call Moana Mackie.
Thank you, Mr Chair, and I'm disappointed that the Minister and the Chair didn't take heed of what my colleague Ruth Dyson said in answer to her question about the commencement date. And I think it has been disappointing this afternoon that we've posed a number of questions to the Minister and the Chair, and all of them have sat there like dried arrangements and done nothing. None of them have gotten up on their pins and actually answered the questions. That's actually what the committee stage is meant to be about. And this is a very, very serious piece of legislation. It has very, very serious implications, not just for the conservation estate, but for the general public, their ability to oppose the government's plans to ramp up deep-sea oil and gas exploration, and what it means for the Minister of Conservation. So it's disappointing that the Minister has chosen not to answer my colleague's question about the commencement date, but he, of course, will have an opportunity in this part. Well, I too don't believe that the Crown Minerals Permitting and Crown Land Bill adequately reflects as a title what this piece of legislation actually does. And I think if I had to rename it, I would probably start by calling it the Crown Minerals This Is the Only Plan We Have Bill, because that's the reality of what we're doing here, which is that regardless of what you might think of oil and gas exploration and mining, whether some people are for it, some people are against it, some people are in the middle, I don't think that there is anyone who would believe that this should be the only thing that we do in terms of economic development and jobs. I don't think there is many people who would say, even in Taranaki, this isn't the only thing that's happening in Taranaki. This isn't the only thing that creates jobs. But to listen to the government, you would think that it is the only thing, because they've put all their eggs in this one basket. This is it. If this doesn't work, they have no plan B. So if all these jobs and all this money that they've been saying for years is going to flow from more oil and gas exploration, more mining, if that doesn't work, they don't have a plan B. There is no other plan for economic development, and in particular regional economic development. And that's why we're seeing the kind of legislation being passed today, and currently the RMA legislation, exclusive economic zone legislation, but today the Crown Minerals legislation, where they are trying to undermine this legislation in terms of its protections for the conservation estate, its protections for the environment, to make it as easy as possible for industry activity to go ahead regardless of the consequences. And I suspect that this could also be called the Crown Minerals This Is Going to Cost a lot more money than the government seems to think it's going to amendment bill. Because the reality is that New Zealanders largely have faith in the process that is currently set out under the Crown Minerals Bill, and the Resource Management Act as well as another example. The minute the public loses faith in that process, actually it becomes a hell of a lot more expensive for industry. When people feel, I have to engage now, I have to appeal, I have to protest, because I no longer feel that the systems that my government puts in place are systems that I can trust, are systems that are going to uphold the highest levels of health and safety, the highest levels of environmental protection, are going to ensure that the preservation of the conservation estate is paramount. As soon as the public loses faith in that process, then it becomes more difficult for industry, not easier. Where the public feels that the process is fair, they'll let the process play out. They'll play their role in it if that's what they want to do. A lot won't, many won't. But this is a false economy. This could be the Crown Minerals False Economy Amendment Bill, because this is opening up so much scope for far more legal challenges, far more judicial reviews than the current system, which has worked well. And members opposite like to talk about Taranaki as being the crowning example of what this activity could achieve for the rest of the country. Well, all that happened under the current Crown Minerals Act, and all that happened under the current Resource Management Act. That's right. So why do we have to really completely undermine these pieces of legislation when all that's going to happen is it's going to result in it being more difficult for industry, given that we now have processes that the public do not trust? So, as I said, this is all the government has. This is why we're taking so much out of this Crown Minerals Act, because they want to make it as easy as possible. I don't think it's going to have the outcome that they think. I think it's actually going to have the perverse outcome of being the opposite. Now, the other thing that we could call this bill, and we didn't know that this was coming up, of course, was in relation to the Minister's SOP 205 to stop protest vessels in the exclusive economic zone from interfering with installations or with vessels. And what we could rename this bill, Mr Chair,
Moana Mackie.
thank you, would be the Crown Minerals Some Dangerous Behaviour Will Be Outlawed But the Rest Won't Amendment Bill. Because the ridiculous situation that we find ourselves in is that the government's saying this is about safety, this is about complying with our international obligations under the United Nations Convention on the Law of the Sea. Well, that's all very well and good, but then why does it not apply to every vessel in the exclusive economic zone? If it's about safety, then why should we not apply the same standard to commercial operators of any kind, whether they be petroleum exploration or fisheries or whatever, or cruise ships or protest vessels? Why should everyone not have the same level of scrutiny and legal obligation as we're putting on these protest vessels? Because currently, under what we're passing here, an activity that would be deemed illegal in our territorial waters under the Maritime Transport Act is not covered by this unless it's a protest ship, and that protest ship is protesting specifically against petroleum and minerals exploration. That is the ridiculous law that we are going to pass here. And no member of the National Party has stood up and addressed that particular point. So we had Minister Finance, and I was embarrassed to see the Attorney-General come down to the House to defend this. We thought he must have a legal opinion. We thought that he must have got a Bill of Rights vet to challenge that produced by Greenpeace and the group of New Zealanders that have supported them. And he didn't. He had nothing. And we could call this legislation the Crown Minerals, the legal opinion you have when you don't have a legal opinion bill. Because two ministers stood up and basically implied that they had legal opinions that supported that SOP. When they were asked to table it, neither of them could because they don't exist. This isn't compliant with our Bill of Rights Act. This does not comply with our international obligations. It is an embarrassment, and it's because this government has mishandled the issue of oil and gas exploration, particularly in the exclusive economic zone, so badly. They have mishandled it to such an extreme that the public are taking to the seas in protest because that's the only way they feel they can get the government's attention. And they got the attention of the government, that's all right. The government's now legislating away their right to oppose what the government does. That is completely outrageous, and it's an embarrassment for an Attorney-General whose job it is to uphold the Bill of Rights to come down to the House and defend it. It would have been better if he'd just ignored it and not come down here and put on the petty show that he did, attacking Geoffrey Palmer, attacking Damian Salmon, New Zealander of the Year, in a display that can only be described as waspish and not becoming of our Attorney-General. And then to, at the end of it, not even have a legal opinion, apart from his own opinion. I guess he's a lawyer, that's the kind of legal opinion. But to not actually have done the work to back up what he was saying, that is a shame on this country that our Attorney-General does not take his very important constitutional role far more seriously. So my colleague Ruth Dyson talked about the fact that powers have been taken away from the Minister of Conservation. And I remember that press conference where Jerry Brownlee sat next to Kate Wilkinson and said this will be a shared decision-making power. And the visual just said it all, really, because Minister Wilkinson sat there and said absolutely nothing and was completely dwarfed by Minister Brownlee, who was Minister of Energy at the time, who completely ran the whole press conference, ran the show. So this could be called the Crown Minerals. No one really believes it's a shared decision-making power bill, because the fact is the Minister of Energy is now in charge of determining whether or not mining will go ahead on conservation land. And we know that that will then skew the current balanced approach towards industry, regardless of the impact on our very, very valuable and precious conservation land. Because this is a very important role that the Minister of Conservation carries out on behalf of the people of New Zealand. The Minister of Conservation is the custodian of the Department of Conservation estate. And it is entirely appropriate that that is the person who determines whether or not the impact on conservation land is such that an activity should go ahead or should not go ahead. And now that's been stripped out. Now it's this shared decision-making power. And as I said, no one believes it's a shared decision-making power. This is once again a national government that is so bereft of ideas to create jobs and to grow our economy that they are having to make these kinds of changes in order to smooth the way as much as possible for these activities, regardless of whether they're carried out responsibly. And where they're carried out responsibly and with minimal environmental impact, that's fine. That's what the current system allows for. And that's absolutely fine. But that's not what's happening here. Now we're saying actually that goes out the window, and the impact on this conservation land, and we will see, I think, more mining projects in Schedule 4, because companies are out there right now having a look at what's out there, prospecting. You don't pay the money to look unless you've been told that you're going to be allowed to go in and get. That's the reality. And so that's a broken promise. This could be the Crown Minerals Schedule 4 promise broken, surprise, surprise, amendment bill, because clearly industry have been told that Schedule 4 will be opened up or relaxed.
I call Gareth Hughes.
Thank you, Mr Chair. Kia ora, ngā mihi nui kia koutou.